they're online. Yes, then. Yeah, we have to. Show. Yeah. Yes, and it would be show them. Nothing. Number 3 on the court is the virtual with an appeal number TAT/SSS/024/2023. Chevron Nigeria Limited versus Delta State Internal Revenue Service. Appearances.
With profound respect to the tribunal, I would like to note that the client is actually represented by Mrs. Uloma Okwechi. So, Uloma, do you want to unmute, please?
Let's have your own first.
I'm not sure.
So, client is represented.
Let's have your own first.
With profound respect to the tribunal, I am Afolabi Elebiju. Afolabi Elebiju. And I appear with my learned friends for the appellant, namely Mr. Ayoleke Owolabi. Ayoleke Owolabi. And Mr. Abdusalam Salam.
And Mr. Salam.
Respondent.
Put our face.
Respondent.
If it pleases this honorable tribunal, my initials are A. Yes, sir. Counsel to the respondent is present. A.O. Gegbada. Initials. Gegbada is my surname. B-E-A-D-A. Gegbada. D-J-E-G-B-A. D-E-A. The respondents are.
Are you appearing with anybody? Are you appearing alone?
ID initials Gegbada.
Yeah.
Yes, sir. D Gegbada.
With who?
My lord, 2 counsel appear me. I the first one. ID.
Gegbada. Oh, yes.
ID Gegbada appears with me. ID Ifeyinwa-Dora.
Okay. ID Gegbada.
ID as in Ifeyinwa-Dora Gegbada. ID Gegbada. Yes, sir.
Yeah.
And EN Boniface. EN Boniface. E for Esther. N for Nigeria. EN Boniface. We appear the rest. Boniface. We appear for the respondents, and we apologize for the absence of the representatives. But I don't know why they're not here yet.
Mr. Afolabi, you said party representative. Who is representing the party?
Mrs. Uloma Okpechi. Uloma Okpechi. ULOMA.
Uloma who?
OKPECHI. Okpechi. OKPECHI.
Okpechi. Oh, CHI. Yes, Okpechi.
Yes, sir.
Yes.
Designation.
Designation.
She's
I am. Good morning, Tribunal. My name is Uloma Okpechi. I'm the team lead payroll unit in the finance department of Chevron Nigeria Limited.
Chief lead. Oh, team lead.
Yes.
Team lead. Finance department. Payroll services.
Payroll unit, finance department.
Please, sirs, I just noticed that the representative of the respondents are logged on. He's online.
Who is that? Who is that?
His name is Dr. Ernest Uzuamaka. Dr. Ernest Uzuamaka.
Yes, I'm here.
Ernest Uzuamaka.
Yes, I'm
Please,
here.
Dr. Ernest, you can unmute and confirm your presence here.
What's the designation?
While also stating your designation.
I am Dr. Uzamaka.
He's the Chief Inspector of Taxes.
Chief Inspector of Taxes, Delta State Internal Revenue Service.
Inspector of Taxes. Let us say what?
Service.
Delta State Internal Revenue Service.
Taxes, the data.
Yes, Mr. Afolabi.
okay. Again, good morning, Honorable Tribunal. So, by way of background, we have a notice of appeal that we filed on the 26th of May, 2023. And essentially, the notice of appeal disclosed 11 grounds of appeal. We're seeking 15 reliefs, and those reliefs have evolved as things progressed. So right now, we are ready to open our case, and our case is essentially that the respondent, is not entitled to any of the stated amounts that they are claiming to be entitled to, which is covered by the demand notices that they have issued against the respondent, or as the matters evolved, to the amounts, to the subsequent revised amounts that they are claiming that they're entitled to. So we're quite happy if the tribunal is well disposed for us to open our case. So we're starting the case on the basis of this pleading, the notice of appeal. We filed 2 witness statements on 4th of December 2025 and 21st of May 2026. And the respondents too, they filed responsive processes twice. The first one is dated 28th of October 2025, and the most recent one, 12th of June 2026. On the basis of these pleadings and processes and exhibits, we're happy, and we're in a position to proceed with the appeal today in terms of opening our case.
Yes, the respondents filed something on the 15th.
It was dated 12. It wasn't filed on the 15th.
Were you served?
Yes, sir. We were served and we responded.
So I'm asking Mr. Afolabi.
Yes, we've been served electronically.
It's a document filed on the 15th of June.
Yeah, dated the 12th of June. We received it by email.
Okay. And then, I know that the case is coming up for trial. And at the last time we said, ensure that the documents you intend to tender are uploaded.
Oh. Okay. Well, from our point of view, with due respect to the tribunal, we have filed our witness statements, and some of them include USBs. And the USBs contain soft copies of some of the processes. Then, but on the whole, we felt that those documents, at least from our own point of view, most of the documents are better presented in hard copy, which is why we actually took the effort to compile them together for ease of review and everything. So, and we have filed. We didn't understand that every other thing that we have filed in hard copy must also still be reproduced and uploaded in soft copy.
Well, that is what we were saying, because if you, in the event that you want to tender a document now, you have to, how would they, we have to show it to the other opponents to see whether they object or not. And it's on our screen that we normally display it.
Yes, okay.
People hearing.
Okay, so in terms of that, we actually have, we were thinking that it is our 2 witness statements and the exhibits. And we were going to urge on the tribunal to adopt a procedure that will be easy and will save us a lot, will save the tribunal some time. Because our exhibits, for example, are 37. So we were thinking that the first statement, which has 5 exhibits, once it is acknowledged and we refer to the exhibits, we were thinking that the tribunal will indulge us with with admitting them summarily. Then for the second one, that also has 32 exhibits, we were also thinking the tribunal will indulge us by admitting them summarily. Then the issues as to whether they are relevant or whether they have any weight, that can be an issue that we'll talk about later. Particularly at address stage.
Mr. Afolabi, what we're saying is, if you want to tender a document, the normal practice is the document has to be shown to the other party.
So very much. Okay, so
habitual hearing, how do you show it to the other party to know whether the party opposes or not? It's on our screen.
Okay, so for we were thinking that we could also share from our screen here, because the processes are already in the tribunal's files and the processes are also with our colleague, that we could show our witness statement 1 and the supplemental witness statement.
They have the capacity to share.
Because they are already in the records of the tribunal. All the documents are already before the tribunal.
Yes, we are talking in case of, how do you show them on the screen?
We will do, if they give us a share screen, otherwise we can quickly email the 2 witness statements to the registrar. But otherwise, if he enables us to share screen, we'll show them on the screen. And our learned friend for the respondents will be able to confirm that these are the processes that he already has in physical form as well. So, because we were, with due respect to the tribunal, we were looking at a process that will facilitate easy admission of the evidence, because there are quite a lot.
We have to upload them, Mr. Afolabi.
We will have to do it.
The exhibits, the documents you need to tender, we have to upload them. We have to upload them.
And then they said we will send
I understand the letter was sent to you
respond.
to identify the documents you want to tender so they could upload, and there was no response.
No.
We?
Yes, that's what the secretary said.
No.
Oh,
There was a communication to
We're
you.
not, we were invited to indicate whether we should apply for virtual hearing, and we did that. And we're not really aware of this very letter, and we apologize actually, but we don't seem to have it.
For the same communication, they said either virtual hearing and then your documents to be uploaded.
Usually for this candidate for fund, which are open for virtual hearing and application.
We-
You didn't read the letter fully. You only
Well,
read it.
in that event,
Mr. Afolabi, what is the way out?
So what do we do?
we
Do we start out?
would respectfully ask that the matter be stood down or adjourned, because our documents are a lot. In fact, just because of this upload, we may actually be looking at coming to do the trial physically, because it is going to be quite and the reason why we did, especially with due respect to the tribunal, our supplemental witness statement, for example, is actually a bundle. It's a huge bundle. It took us a lot of effort to put together. So we'll probably, with due respect, and we'll probably come and do physical trial, because the energy, putting all this together, especially because there's also a USB in the bunch. So that USB, we would like it to be the way it is described in our processes. So
Well, I mean,
if the tribunal will indulge us, we would ask for.
I was indeed surprised that you opted for virtual hearing today.
As a matter,
Considering the working documents you have. But let's hear from
yeah. Okay. Thank you very much. Okay, maybe after he has responded, I have a little observation actually, but after he has responded. Thank you, sir.
Yes, you're welcome. Mr. Ajibada.
Thank you, Honorable Tribunal. On my part, while I appreciate the constraints of learned counsel to the appellant for things to be tidy and more orderly, I would also toe the line of the Honorable Tribunal that the said document be uploaded. And if the said document cannot be uploaded today, a short date can be taken for them to do that. That's my humble opinion for now. The said document should be uploaded since it's virtual hearing. So,
I can upload. If we can't upload, then we have a physical trial.
We provide respect to my learned colleague, and we provide respect to the tribunal. We will crave the indulgence of the tribunal and the understanding of our learned colleague for us to have that short adjournment to be a physical hearing. As a matter of fact, there were one or two developments that came up at our end, and it was considered, especially when we got the more or less the invitation that if we want, so we then basically felt maybe we should do it. But we were also assuming that because all the documents are already before the tribunal, so we would really appreciate if the tribunal would grant us an adjournment for us to do this trial physically.
Can we give you 13th?
18th.
13 July.
13th of July.
The Monday.
It's convenient for us from our end, Madam. 13th of July.
Yes.
What's your calendar like on 13th of July?
my lord, unfortunately, that date is not convenient for me. I have a matter scheduled for that date for hearing, sir. That's 13th of July. I'm so sorry. But it's not convenient for me, sir. If you can do 14th or 15th, rather.
You'll be on ground physically.
15th.
You didn't speak on the other one.
Yeah.
Appearance physically.
See you.
what your colleague had advocated, physical.
I will try, even though it may not be convenient for me, but I'll see what I can do about it. Even though I would have appealed that I conduct my cross-examination virtually, if that would also be okay to the Honorable Tribunal. But in the event that is, it won't be practicable, then at that point, I will have no other option but to look for a way to appear physically. If not, ordinarily, I would humbly and most respectfully appeal to the Honorable Tribunal to allow me conduct my cross-examination virtually.
Once the documents are uploaded, we don't have a problem with that.
And
So
And
the
we
problem
ask-
with including the documents. What documents
I think
are?
counsel,
no, and we
I
should
think
add,
answer to the
sorry, sir. So we should add, sir, that we have no objection to that for learned counsel to cross-examine virtually, but we are going to be there physically.
Okay.
So we don't have any issues with that. He has all the documents already, and we are to be before the tribunal.
So,
Oh,
Mr.
I
Adebada,
don't-
since you are not cross-examining on the trial date, we can take the 18th. Because our diary is,
it's okay, sir.
we can
It's
take-
okay. We can do the 13th.
We can take the 18th, then somebody can stand in for
We
you.
can, sir.
Yes.
As the court pleases.
So, Mr. Folabi, 13, you say it's okay
Yeah.
for you.
Yes, sir. I was. It's okay for us, sir. But we were thinking that the case be opened and closed same day, if possible, subject to the schedule of the tribunal, so that witness
How
can
many
be
witnesses?
discharged.
How many witnesses?
Just one witness, sir.
With all those documents you have, you want to do the
It's just one witness, sir.
No, if you're with we can put your witness.
we will show when we are doing the trial, sir, that there's a summary procedure that we believe the documents will come in.
Mr. Folabi,
Yes, sir.
you can finish all the evidence in that day. And then we are done for Jebada to cross-examine visually.
They will do that virtually.
As the court
Okay. As the tribunal places.
There's no way you can open that matter that day and close it that day.
So, Mr. Jebada will not-
The challenge we have is that our witness is overseeing so many things, and she's always engaged with so
The
many.
cross-examination will be virtual. Cross-examination will be virtual, so you can cross-examine from anywhere.
So it's virtual across.
At the tribunal places.
If I may add also, my lord, this case is quite a complicated one. And I know counsel to the appellant appreciates that fact. It will practically be impossible. I'm even looking at the possibility of me cross-examining for 2 days because I have some issues that would need to lay bare before the honorable tribunal. I'm just being honest, and I know counsel to the appellant knows this.
So let's do virtual then let's do physical then. You know, if that
Yes.
if 14th and 15th are convenient, as my learned friend has said, and
Sorry.
subject to the convenience of the tribunal, we can look at 14th
You
and
are calling
15th.
for physical. Are you saying 14, 15 for physical, or you are?
No, 13th or 14th, no. They don't really-
Yeah, we're suggesting, since 13th may be a bit tight for learned counsel, that maybe we can do 14th and or 15th.
No, we can give you 13 and 14th.
Okay.
13th and 14th are fine, sir.
Huh?
13th and 14th are fine.
Yes, can give you 13 and 14.
At the tribunal places.
We're grateful, sir.
We're much obliged.
Okay.
We're very grateful.
We're grateful.
Mr. Folabi, I didn't take you down. Maybe let's have something down. But we're still trying to find a way, best way out for the trial. So let's have something down for today.
Is that for us?
I think it was.
Sorry, sir. We're not following, sir.
Just summary, something at least.
Okay, yes, okay, thank you very much. So the summary is that we were seeking an adjournment in order to be able to do a physical trial, given given the challenges with undertaking a virtual trial today in the light of our evidence, which are a lot and which are not yet uploaded? And we're therefore humbly applying that the matter be adjourned and that at the next hearing, it will be a physical hearing.
Yes, Mr. Ajibada, briefly.
Yeah. On my part, sir, we are not opposed to the application for adjournment. However, we'll be humbly appealing and applying to this honorable tribunal to allow counsel to the respondent appear virtually and also conduct the cross-examination virtually. We are grateful, sirs.
Although counsel, we thought by the time we agreed on 13th and 14th that you were going to, you know, there was going to be physical since it was going to be 2 days.
Counsel to the appellant admires my face so much. He wants to see me physically.
Even the tribunal.
Yes, you will look you very much so. You already look good on the screen, but I'm sure you look much better physically.
Thankfully, my wife is here to hear that that very beautiful compliment of my handsomeness.
Madam, please take it to heart.
I was going to ask you if ID Chegbada is a coincidence. Let's see, Madam.
It's a beautiful coincidence. She's my learned wife.
Let our mood. I hear
Good morning, Honorable Tribunal.
Good morning.
Good morning, learned seniors and colleagues.
Okay, you're welcome.
Thank you very much.
But at this morning, you want to keep it inside the house alone. I mean, keeping this money inside the house alone.
Okay, the office.
No.
Well,
Okay, the money. The
Morning,
and on an additional note, with due respect to the tribunal, we're just restating our understanding that we're coming physically, and therefore that will relieve us of the need to upload.
No, what happens is the upload will be undertaken by the secretariat for purpose of the cross-examination. But you come and do your physical hearing, tender all your documents.
But
the
secretariat already have 2 copies of our documents.
No, Mr. Porabi, after the hearing on the 13th, we know the documents that you have tendered, and then those documents will be uploaded for purpose of examination.
Okay, much obliged.
Yes. So you must have the physical hearing on the 13th. Then we know those documents that you have tendered, then we upload them. That will be the business of the secretariat.
Much obliged.
Yes.
just want to ask, please, is it, am I required to be there physically as well?
Sorry,
I think so.
is
I
that for us?
think so.
Is that for us?
I think
Yeah, the witness was asking a question, and we said we think so, but we will sort things out internally before then.
What's the question?
The question was whether she's required to also be to be before the tribunal physically.
Exactly,
And we
yes.
said the answer is yes.
Yes, because if she doesn't come, then the problem we are trying to avoid, to upload. Because we have to upload for her to tender. To see and then tender. So she has to be here physically for the.
To tender
Yes.
those documents.
At the tribunal places.
By consent of both parties, this case is adjourned to the 18th and 14th of July 2026 for hearing. And counsel to the respondent, O.J. Bada, is granted leave to attend the hearing virtually.
At the tribunal places.
We are very, very grateful to this honorable tribunal.
We're much obliged.
So the next test.
Number one on the top plate with appeal number TAC/SSS/0TH.
Sorry, madam, Bobon, the other counsel is not here. Okay, we'll get there. Number one.
yeah.
Number one on the top plate with appeal number TAC/SSS/0TH/2023. Stanbic IBTC Bank PLC versus Empire State Internal Revenue Service.
For respect, I equate for the appellate.
This one in. Party reps. This one and any later. No, that is. Correct.
Everybody, my was our terms for the events. So that was it when I came in for hearing on the 20th of May, 2026.
We're looking at defense.
Yes, sir.
Yeah.
As the respondent applied for an adjournment, and today they're not in court. They're not in the tribunal, and no,
Were they here the last time?
no, they're not here, they look for an adjournment.
Okay.
They are
Let me
quite
take it up. They will discuss about the work on it.
came up on 20th of May 2026.
Thank you.
May 2026.
Yes.
The respondents applied for an adjournment, which was granted by this honorable tribunal.
But if it's already evidence for the roots.
No, I think they look at the back. You look. And the matter was adjourned to today. So one of the dates suggested by them.
So it was adjourned from February to today.
Yes, because adjourned to this year. Yes. I believe they're not fit, Sabrina. And no communication from them. Yes. In view of this fight, in view of this, you want to apply that to closed.
Yeah.
That's application.
That's for closing witness.
It's for a cross address.
But your submission is not complete.
Okay, well, when they apply that, they should foreclose and the matter should be adjourned for adoption of written address.
She's not filed the original address.
For parties to file their written address. For parties to file their written address.
Did they start their defense at all?
They started that they got stopped.
Did they start there?
They started on 8th of September 2025. They opened the defense and we got stopped and then applied for adjournment. 8th of December. No, 8th of September.
2025.
Yes, sir.
Have they paid your costs? The costs?
No, they did not pay. Vote since
There was a definite date given for payment of cost.
yes, because it should be not the account number today.
On the 14th of April, the council to the respondent requested for account.
Yes, sir.
Why didn't you send it?
I wanted to get across to my clients. I'm not going to do that.
You won't be able to.
No, I'm going to. I need to send a mail to them that should publish us with the account that they need.
So why is it taking so long?
We'll do the needful.
So we can't blame them.
No, I'm not, that's right. I'm not.
Let's send them account, so what? Is that?
No account, you cannot expect money.
We'll do the negotiable. Look at the first one, 8th of September, 2025.
March, and not yet, what no competition. Network, that's the came on. And then, but just for having ability to do the government of the United States. Not done to me. Maybe to make the difference. The government that it must do.
Agenda today. Definitely here.
They look for alternatives. And they suggested this, yeah.
And the top.
The best water.
Go ahead. Yes, sir. We do this is from the provider. This is from today, and then we'll give them opportunity also to file a reply. But I'm not in this questions of being it means 30 days or 30 days. Today is June 19th. Number. They always go to the it's last week of the so you're going to be yes. Just the first one year. Okay. Still the last last Monday. So take the people, so takes the use of things. So whatever happens, we really have this. If it be no, so international problem. So look at this. I think that the development of this is from this. We go to simple. Yes, two of this. I didn't for you. I'll be doing something. Thank you. So, yeah, it's a bit in others. Is that this? We should go now confirm. Yeah, almost whether it's not necessarily identity time. So the other of it will not take us. Who wants your other days? Not as it's I am reading this. There we go. Thanks. Roll call. Thanks. You get it, right? Like that for us. So Monday. No, let me check. Many weeks. Go ahead, thanks. Thanks, of course. Take the phone off. What we are giving August is you file within 30 days.
Yes,
We serve them. We are giving them time also
to respond.
to respond.
Okay, fine. Subject to convenience of the tribunal, 10th day of August, 2026.
The records of the tribunal shows several adjournments at the instance of the respondent and a lack of seriousness and commitment to conclude the defense in this appeal. The adjournments to allow the respondent to attend the tribunal and defend this appeal cannot continue ad infinitum. This tribunal is therefore inclined to conclude the respondent at this point. The applicant is therefore allowed an order to file his final written address within 30 days effective from today. The respondent is granted 30 days after service of the applicant's final written address to file his reply. This case is therefore adjourned to the 10th of August 2026. Adoption of final written addresses.
I cannot please.
Hearing notice is hereby ordered to serve the respondent.
I cannot please. I very good.
Just
Number 2 on the cost list with appeal number TAT/SSS/012/2025. Bicester State Board of Internal Revenue versus Seafloat Marine Services Limited.
With utmost respect, Mr. Chairman, and honorable members. My name is I.M. Benjamin. I appear for the appellant. There is no representation.
On humility to this honorable tribunal, I am U.F. Amadasu. Number of appearances for the respondent.
Yes, any party rep, no? Yeah, Bebe,
It's not a competition.
the case was adjourned today. What are we doing today?
Well, this whole, the documents that, my lord, order that we provide, my lord, which are certificates of approval of life craft service station for 2019. We have that. Also have the salary analysis of.
So you want to tell us something, the document on the back? Where's the witness?
The predicament I'm having is that we were sent a link. And if to indicate if we want to use yes, my lord. So me, I'm always here in Benin, but the witness who is still in the witness box. So I sent the link to him. So immediately it was sent to me, though a bit late, I must be frank. And I sent it to him that they sent the tribunal administrative office sent this one to us. So if you know you will not be able to make it down. So let's indicate and follow the instruction as was provided in the link. So I didn't want to start interpreting. That's why I sent everything as was sent to me to his WhatsApp page. So it was only this morning, he was now telling me that he's going to opt for the virtual hearing. I said, no, let you read the instruction that is there, that there's even a time limit within which you are to indicate your interest by way of your application that you want to be held visual. So that's the predicament, my lord, this morning. If not, because I was thinking that okay, since he didn't either he has done that or is going to come down.
But yeah, the documents are available.
Yes, my lord, the documents are since last time it has been available, just that they were not around at the last he said he wasn't feeling fine. So we have to take today's date. If not, the document has since been ready.
Have you given him a copy?
And I gave him before, but they were not clear because that was part of the reason why we have to adjourn. So last week,
Even if you were going to, even if the witness was going to the virtual, then we ought to have uploaded.
Okay, documents. I'm very sorry, my lord, as the challenge I'm having this morning.
Where is your witness?
Sorry, man.
Where is the witness?
The witness is in Port Harcourt.
What? You know, I'm assuming the recruiter was with this, some documents. You sure we have that?
Yes, I have the documents, my lord.
That's not available.
Yes, madam.
Yes, available. You pay them, you'll be okay, definitely.
Yeah. And why they want to file additional? Or they want to just tender it?
It's not them who wanted to submit it, we ordered them to produce them. So it's only tidy that it should be.
I just want to be reminded with the order that was made.
So I'm coming to it, so I just tidy that they should tender them to the witness. That will mark them as certificates.
As we come, please, we
That's
say,
why we need the witness, but that's why I was looking at the records here. On It was in the course after the cross-examination.
Yes, my lord.
After the cross-examination, in the course of the cross-examination, there are some issues came up
Yes, my lord.
on the,
Oh, and the 20 years,
there was some,
Yeah, 20th of September, my lord. 2026.
on the 20th of February.
Yes, my lord.
And these were the documents we ordered after the cross-examination. And about that's what I said, for the cross-examination, we said no re-examination. So we now ordered that the tribunal now said some documents were referred to by the DW1 because of the cross-examination by the appellant. So I see the tribunal do justice in this case, the appellant is ordered to produce the following more documents on the next agenda. One, approvals for 2019 to 2021. Names, position, salary structure, and addresses of employees of the respondent. C, timesheets. D, invoices issued clients. Those are documents with others.
As the court plays this one.
One is said on the 15th, we came, 15th of April.
On the 20th, my lord.
Yes,
the court
yeah.
plays.
There was here. And this numbers, no. I wanted to say some of the documents were not ready.
Yes, my lord.
And asked for that if we could, we are not putting the application. Yes, was adjourned to the 1st of May. And the answer to the respondent was reported to have been disclosed.
Yes.
Person disclosed. Number does it say we are not opposing, we are not asking for further, we are not opposing. And we asked for further dates, which was adjourned today.
Yes, my lord.
So let's take a date, you will let your witness be available. If he won't be available, if he won't essentially, then the secretary should know on time.
Okay.
So that they will upload the documents.
Okay. As the tribunal.
If it's attending physically, they don't need to upload.
I will, when I step out now, I'll put a call across.
I will not wait next date again.
As the tribunal, please, I'll take step.
Agree on the dates. Can we take that in? Then the loss for them to tender those documents.
Yes, ma'am.
We will have resources out.
On the document.
Yes.
The guy can do that for you.
No,
He cannot, or you don't want him to.
no, he cannot.
That's the guy.
We have not done much try.
That's why I should be appearing with you.
But
Should be appearing with
we all have family issues, but I'm still here.
you.
I'm still here.
Can we give you 16th?
It's very okay for me, that's 16th of July. Very okay, my
It
lord.
is coming. Yeah.
I'm not good for my.
Wait. For this is. So, then, I didn't take it down. What is it?
You are not opposed to. Education and material goods. However, we are in receipt of some documents. Which we have the opportunity to look at it properly.
Right, consent of both parties in this case is further adjourned. The 16th July 2026 for the respondent to produce the document ordered by the tribunal on the 20th of February.
The tribunal pleases. We are most grateful.
Next question.
Last of the court slip is appeal number T80/SSF/008/2024. That the Bongo Inter Oil Nigeria Limited versus Delta State Internal Revenue Service.
Back on this, yes, this is all this on what? Yes. Wrong. Wouldn't you do that for like yeah. That's interesting. It is really one to go to now, but we have to tell you what it which says. There's no you send it to prompt for one to go back from the bottom. The rule says, you don't put it on, we should not you now say on something. Appearances.
May it please this honorable tribunal. My name is Monwan Edwin. Appearance is for the appellant.
May it please this honorable tribunal. P.O. Marshall. For the respondent.
Any party rep?
None, Mr. Chairman. Oh, I apologize for that.
Mr. Mowan.
Yes, Mr. Chairman.
Okay, I just, it's just this morning I knew that you are attending virtually.
We apologize for that, Mr. Chairman.
Yes,
Sent our letter since last week.
we can't hear you well. We can't hear you well. Can you speak to your speak to the mic?
Okay, so I said we sent our letter since last week. Our application letter for virtual hearings since last week.
Sit down, maybe sitting down will be better.
Yes, I can see somebody behind you. Are you in there?
I'm in the office. That's an amicus. It was the one of the people handling the matter before I joined. It's an amicus. He wants to say hi to Mr. Chairman, but he's scared if Mr. Chairman.
Well, if you can hear us, the ruling is not ready. Says the panel wanted to meet with you and the counsel to the respondent. But now that you are not here.
But Mr. Chairman, I am present. I am present.
A panel wanted to meet you and counsel to the respondent in chambers.
Oh, we're not privy to that. were privy to that.
Eventually. But you're in Benin?
No, I'm not in Benin. I'm in Lagos. If I was in Benin, I would have been in the tribunal.
Okay. The party wanted to meet the two of you, chambers. So, you know, at the last agenda, there was something Ms. Omar Sweeney was trying to raise, which I felt was not good for public consumption. Madam, I don't believe that has been resolved. You were saying that it's like there is an attempt to. You understand what I'm saying?
I understand.
Yes. There is an issue we just wanted to address between the two of you. You see, has it been
I'm not believing with my colleague, I can normally report to. I need to, I want to resolve with them. But for them, at least, I want to play, I need to present a receipt of what was paid. I want to make my claims, but I don't have any claim like that. Maybe something I need to resolve by, should I say like, principal according to the board. Really endorse it.
because we feel a bit concerned that it's not good practice. It's not good practice if limit council, if practitioners will be involved in the yes, even if you are taking a brief from another council. I mean, if somebody briefs you and the council had been in that case, you will have to clear. I think that's what I learned in the law. We have to be sure that the council who was handling that case has been paid and there are no issues before you take over the brief. Mowan, are you hearing me?
Yes, sir. Yes, sir. Yes, I can hear you.
At the last agenda, Mr. Masone raised an issue
That were very
that were fundamental, which I felt wasn't for public discourse concerning fees.
Mr. Chairman, I thought we were able to clarify that the last time because when she raised the issue of that we were going to talk to our client directly, we said no. And that even the terms of settlement was first of all sent to her, and which she acknowledged that was sent to her. And we were expecting them to get back to us with respect to, okay, we want you to add this clause to these terms of settlement, we want you to add this, this paragraph to this, to make it this way, to make it this way, so that the parties will be at Eden, and then we'll file the terms of settlement. Unfortunately, even as we speak till today, they are not yet back with the terms of settlement. So on the issue of saying that we were talking to our clients behind our back, we did not do that. We have a reputation that we want to protect, and we will never engage in such kind of practice.
They are the appellant. I don't think it bills on us to file the terms of settlement. They are supposed to file the terms of settlement.
Yes.
So what was sent to me, I don't know if you can show it. It's blank. It doesn't state anything. It just said, according to what parties have agreed, we now file. And I said, I just did a genuine. I would have left it and then allow them to send it to me. And I said, there's really nothing in what stated, what was agreed upon. It just said blank, according to as the parties have agreed. We hereby file. I just made my own general that they should at least let us have something that was. There won't be something we agreed to such and such an amount. That's why I said it. So the next thing I started hearing was that we should now file. I told my colleagues, they are told I cannot file anything. So I have to work out with them, and it's okay with the board. They cannot file. It's not for us. They were not asking me to file. I said no, that's not the proper thing. I think he is company new. Yes.
Mr. Mowan.
No fight for stop.
Mr. Mowan, please, for the integrity of our practice as practitioners,
Yes,
please, these are the two issues that we will give you. We will take a dates. Then we will get the ruling ready for the next dates. But I want both parties to resolve those issues surrounding the terms of settlement and Mr. Masone's entitlement.
Yeah.
You understand? I said, I'm not comfortable. There's somebody behind you. There's somebody behind you. Is it part of the? Are you agreeing with?
No, it's like I said earlier on, Mr. Chairman, he's an amicus. He's one of the people that was
Amicus?
Yes.
Did the tribunal ask for an amicus? The tribunal didn't ask for an amicus. You want to appoint the.
Just
You want to
the way
appoint an
I
amicus?
that day when I was in court at the tribunal to greet the tribunal. That's the same way he's there.
You want to appoint amicus on the tribunal?
I am not appointing it. It's not.
It's the tribunal that should ask for amicus, not you.
Okay, sir.
So,
But he just wanted to. It has been a long while since he saw your face, Mr. Chairman.
So please, I mentioned 3 issues. Try and resolve them. Both of you should try and resolve them before the next days. So on the next days, whatever you will agree, we will give our reading. Hear us. You heard what we said?
Mr. Chairman, I didn't get you.
I said there are 2 issues involved. The terms of settlement, if you have got, then the issue surrounding Mrs. Owasone's professional fee. Those are the 2 issues that I said shouldn't be discussed in the public. Yes. For the integrity of our practice, I said.
Mr. Chairman, sir, I think if my memory serves me right, at the time when we filed this matter, she was still working with the tax authority. And also, the issue for fee is something that she has to discuss with her clients. Because given the situation at hand, like I said earlier on, that she was in copy, or we sent her a copy of the terms of settlement. And the practice for resolving disputes, amicably in that manner is that when we send you, you make your findings and then you come back to us and say, okay, this is what we want, or you send us a redrafted copy, which they did not do at all. And even up to now, they have not sent us any copy with respect to that.
Well, I don't think they're trying to suffer your issue with your. So we will take a date for ruling. We will get our ruling for the next 17th for the ruling. 17th July for ruling for the ruling.
Amicus.
You are looking back.
He's looking at Amicus. Amicus advised him up to date.
You want the amicus to advise you whether 17th is coming there?
It's
more one.
Yes, sir. It's not
You
about
want
the issue of
to advise you
17th.
whether 17th?
Yeah, so it's not about the issue of 17th. My concern is that the council on the other side has not filed anything as we speak till now, and she has not also.
We have gone past that. I say 17th for the ruling. So I'm asking whether it's convenient to you.
July.
17th July.
17th July, it's convenient.
Really?
It's convenient, but Mr. Chairman, if I may, subject to your prerogative, sir, if I may, number one, I think they've not filed anything, and then secondly, she has not made any claim that there's a new counsel in the matter, and then we did not do our duty to ensure that she's paid since they are giving her of representation. So the issue of fee at this point is something that she needs to discuss with her client and not us. Thank you, sir.
This case was adjourned today for ruling, but the ruling is not ready. And it's further adjourned to the 17th July 2026 for ruling. 17th July for ruling.
We are graciously obliged, Mr. Chairman.
Huh?
I'm grateful, sir.
Such yourself language.
I will.
It's unfortunate that.
They didn't even call you, they didn't even talk to you.
I talk to my tribe. The problem is if they pay, I need to have a receipt of what was in them. I need to have that I can present. That's where I have challenge. If it's an amount, I need to have what I'm not going to be bored now. I don't know.
They didn't know how much they're right.
You don't know.
They didn't know how much they're right.
Yes, and it was 9 million. That's what was.
You were supposed to pay a percentage.
Yes, that's why we having that challenge of getting that. Well, I understand what is wrong, but they are not. I
So
want
who is meant to pay you?
She's the board. Yes, the board. The board.
So
That's the point one is making.
yes.
Payment is not in someone's business.
So, just a suggestion, sir. I think it will also be beneficial for us at this point that she has a discussion with our clients, the respondent, this matter to see. Because what is holding us back at this point is, like rightly stated, is our fee, and we are not responsible for our fee. Like I said also.
We understand you. We understand you. We're not saying you are responsible.
Yeah, and then also there is also no dispute or conflict as to whether there's a new counsel representing the respondent in this matter. If there were, in any case, Mr. Chairman, believe me, we would have pursued with all diligence to ensure that she has been rightfully, paid. But at this point, that issue has not. It's not.
We agree with you. That's why we say she should sort herself out. So we take our ruling on the 17th. But you're not comfortable with that?
It's like because they know what I know you paid for.
I'm comfortable, sir.
What is happening? So
I'm comfortable. It's right there to follow.
All right, so we rise.
Travelers are not resting. Let's see.